Hi, welcome to SouthernOregonDefense.com and the Law Office of Justin Rosas. My name is Justin. I've been practicing here in state court for roughly 17 years and in federal court for 12 years. And I'm here today to talk about what to do if you or someone you care about's been arrested for a DUII, predominantly in Oregon, but also this advice does apply around the country. So many people come in or call after a first-time DUI in their family, and their fear is through the charts. Not only has somebody had their arms held behind their back with handcuffs on their wrists, a very painful way for hours, ended up held away from their own decisions in someone else's custody for a while, and then either spent a night in the detox or sobering center or spent a night in the jail, depending on the discretion of the officer. So many things feel threatened by a DUI arrest: our ability to drive, our connections to our family, our ability to work and continue in our professions, and whether or not we will continue to enjoy the same quality of life based on our values as we had before. So often families are torn up over a recent DUI arrest, and then they turn to the internet, start seeing things like maximum punishments and stories of other people's DUI sentencings without context for the differences in laws where they're at. And that could just fuel that fear and fuel those emotions. First off, my biggest advice to somebody that's been arrested for a DUII, other than scheduling a consultation and dealing with it, is to also deal with the bodily trauma. And what I mean by that is, you're racking your mind, your body hurts, you're stressed, you're unlikely to be eating the way you normally eat. And you're unlikely to be sleeping the way you normally sleep. And so some physical activity, for some people, grounding activity, for some people, exercise activity, whatever it might be, working on your body and trying to get your motion back and trying to recenter yourself in your body is a big part of making good decisions as this case goes forward. So I know it seems like funny advice to lead with, but I always find that if anything is going to help with that anxiety in the early days, legal advice, but also some bodily movement and reconnection with yourself and some acknowledgement that things hurt and that you kind of got to take some time to make sure you're doing okay, rather than just trying to think straight through the thing. Most people are cited for DUI, not taken to jail, especially for a first-time DUI. And there are some accelerators for people that have multiple DUIs. We'll talk about that in a minute. But most people are cited for DUI. Often they're also cited for reckless driving. That's usually a companion charge that police officers are taught to file. And so it does not mean that there are necessarily going to be additional consequences. It's just another charge at the beginning of the case. Usually that citation also depends on the process. So often someone's pulled over in a car. Maybe a police officer's been watching a restaurant or bar and they pull someone over who leaves the bar, do field sobriety tests, take the person to a breathalyzer, and the person blows over. And then they take them to detox and write a citation. That would be the stereotypical script for an average DUII. And there are many variations of that, as I've learned over 17 or 18 years, and we got some stories to tell. But that's the typical script. So in that situation, you'd see a number of pieces of paper that you need to look at and deal with. One would be an implied consent combined report. And this can be if you refused a breath test or if you blew over on a breath test. And you want to look at that quickly because you only have 10 days to request a hearing over whether or not your license should be suspended if they checked the boxes that say that you either failed or refused to submit to a breath test. There are certain circumstances, which I won't get into today, where you could also be required to submit to a blood test. But you want to look at the implied consent combined report that you're given. It's a large yellow triplicate piece of paper. See whether or not they proposed a suspension. And if so, you've only got 10 days from the date of the incident to request an implied consent hearing. It's pretty easy for an attorney to do because they do it all the time. So most attorneys are going to do that for you at the time of your consultation if you just get a consultation scheduled in time. Otherwise, you would need to go to the DMV website and figure out how to submit an implied consent hearing request and work on getting that. What an implied consent hearing does is gets you a time before an administrative law judge. The officer has to show up. They bring their police reports. You can subpoena their video. And the administrative law judge puts them through essentially a script meant to collect or testimony and evidence and look for errors in the process of the way that you were taken to the breathalyzer or in the way that you were asked to take a breathalyzer. And there are a number of different challenges there, including whether there was a valid reason to stop your vehicle, whether there was a valid reason to begin to talk to you about things other than the traffic violation that led to the stop of your vehicle, and then whether or not there was probable cause of an arrest whether any efforts to communicate were honored. In other words, if you asked to call anybody in the world, that they gave you time before they asked you about the breathalyzer to call, spend time privately with the telephone. Even if you can't get through, they don't have to make sure that you get through to a lawyer or get through to someone, but they do have to honor the request to give you time before the question of whether you will take a breath test or not. And then there are procedural issues, both with notices, with the paperwork, with the way of submitting someone to a breathalyzer, making sure that's done appropriately, and certifications that have to be held both for the machine and for the person using the machine. So those are the types of defenses that get deployed at an implied consent hearing, and the officer has to be there to testify. If the officer does not show, the hearing goes in favor of the petitioner, which is the person requesting that there's you or your loved one, the person requesting that the suspension be lifted. That hearing actually happens within 30 days of the incident, meaning that it happens before the temporary permit expires. And that's another piece of the implied consent combined report that you should have, which is a temporary driving permit for the 30 days after the date of the arrest. That gives you time to have due process and have that implied consent hearing in the meantime and challenge it before they actually suspend your license. If you refuse a breath test and you don't have any of the enhancement factors, your suspension is for 1 year. If you fail a breath test and you don't have any of the enhancement factors, your suspension is for 90 days. Those suspensions go into effect 30 days after the incident, and you are eligible for a hardship permit in each of those circumstances. For the 90-day suspension, you're eligible for a hardship permit after 30 of the 90 days. And for the 1 year suspension, you're eligible 90 days into the 1 year suspension. That is the set of punishments for either failing or refusing a breath test that are imposed administratively by the DMV. I know that's a lot of words, but that's just a DMV thing. It's the easier way to say that. That's one part of the process that you or your loved one is going to be dealing with. Another part of the process that you or your loved one is going to be dealing with is the court process. So that's when charges are filed. There should be a date for an arraignment at the bottom of the citation. Those dates can change, and there can be changes in the charges and other procedural changes at the district attorney's office prior to filing. So it's important to keep up with the case and make sure that you are checking your mail to see if your arraignment date has changed, and then B, also just making sure that you're keeping informed about the process as it goes through the DA's office. They won't get your case for several days after the incident unless you're in custody for some reason. And so they won't have the police reports immediately, but they will get them in time. And there may be evidence they want them to see, either the video or go back and forth with the officer about some issue on the case. And so in those situations, they may take longer than the citation that was envisioned. So you want to kind of check. You can also check with the Jackson County Circuit Court or with your attorney, obviously, who would be informing you if you decided to hire an attorney. There you begin usually by pleading not guilty and requesting all the police reports, the recordings, and the evidence. That way your attorney can look through those things and see if there are defects in the evidence or mistakes that were made by law enforcement or anything that there could be to soften the punishments. And then there's a pretrial conference later on down the road where you can decide whether or not you want to change your plea to guilty or whether or not you want to proceed to a trial or proceed to motion hearings, because you can challenge all those things we already talked about, whether the police officer had a valid reason to pull you over, whether they had a valid reason to expand the scope of the traffic stop to talk to you about alcohol, whether they did the field sobriety test correctly, or if not, documented a refusal correctly by reading a Roar's admonishment. Then whether or not there was probable cause to arrest a person for DUII, whether they read Miranda, and if not, all statements get excluded after the time at which it's a custodial situation, and then whether or not they honored a process to communicate and how they did with the actual scientific and evidentiary process of the breathalyzer. So, and there's also other defenses in circuit court for the trial, for instance, for a DUI, like they have to prove beyond a reasonable doubt that you are intoxicated. That's different than just proving that you refused a breath test. They have to prove beyond a reasonable doubt that you were driving. And sometimes there's a little issue with whether or not they can actually prove that my client's driving. And so there are defenses in circuit court that are not there at the implied consent hearing, but you've got time to analyze those and make a decision. If it's a first-time DUI, that decision is between the diversion program in fighting the case. The diversion program has a few steps. There's a $490 fee that you have to pay to the court. There is a 12-hour drug and alcohol educational class that you have to go through at a certified provider that will also UA you. That's give you your analysis or P tests for whether you're consuming alcohol, marijuana, or other non-prescribed controlled substances while you're in the class. If you have a medical marijuana card, you can consume medical marijuana while you're in the class, but you do have to have the card. There's a 2-hour class called the Victims Impact Panel where you watch essentially car accident videos or people that have been in terrible DUII accidents telling you about the horrors of DUII in an effort to dissuade further DUII occurring. If you blew over the legal limit, then you are going to have to put an ignition interlock device in your car. That is essentially a breathalyzer that you blow into at the beginning of any trip and then every 15 minutes throughout the trip in order to show that you have no alcohol in your system, and it takes a photograph of you and then lets you keep driving. Those are about $80 a month. It takes a couple $100 to get it installed. You technically have to have it for the entire year you're on diversion, but as long as you don't blow alcohol into it, which seems easy, and get the class done that we just talked about, then you can get it lifted out of your car after 6 months. You just have to make sure you get the order from the court, or your attorney gets the order from the court, alleviating that burden after 6 months. You also have to do a drug and alcohol evaluation over at the probation department. All of these things can be done in other locales. They're available throughout the country, and you can do that evaluation telephonically. And there's a $150 fee for that evaluation. If you jump through each of those hoops, plead guilty or no contest, they set the sentencing out a year, make sure you don't get a DUI for a year, and then at the end of the year, the case is dismissed against you with no additional license suspension. So you can honestly say you've never been convicted of a crime, and you've never been sentenced for a crime. It is not removable from your record. In other words, a person can see that a diversion occurred on a DUII if you choose to go that route. If you choose to fight the case, then you have all of the defenses we've discussed and all the opportunities that we discussed. You cannot enter diversion once you begin to fight the case. Once you have a substantive motion hearing, is the legalistic way of saying, once you start swinging at them, you cannot make the decision to then go back into diversion. And so the opportunity to get it dismissed goes away. And if you lose, it goes on your record, all the same conditions, all the same programs, also adding in a 1-year license suspension and 80 hours of community service. So that is the incentive, or the carrot that the legislature dangled to get people to go through diversion. Those are the incentives. And that's the decision point that you make with your attorney or with those you care about and are counseled in. What that does mean is if it's a first-time DUII, you're basically out of the realm of being sent back to jail unless you fail to show up at court or make some serious mistakes in the meantime. And it's not likely that something is going to have to end up on your record, even in a worst-case scenario. Those things often alleviate a lot of stress up front, a lot of stress up front. And so the other reason why you want to get into a consultation with somebody is so that you can talk to them about your situation and they can give you tailored advice to your situation, because it's likely to take a lot of the headaches that you have away and allow you to get back to re-embodying yourself after the trauma of the DUI arrest. There's a lot more topics related to DUI, obviously, but this is at least a beginning lesson in implied consent hearings, being charged with DUII diversion in the state of Oregon. Again, SouthernOregonDefense.com. I'm Justin Rosas. Thank you for listening to us today.